Hi, this is Melissa Jakowski, and this is my persuasive speech for public speaking class at Pennsylvania Highlands. Today I'd like to talk to you about exclusionary rule. In order to understand the exclusionary rule, we must first understand the basic principles of the United States Constitution and the Fourth Amendment. Because of this amendment, every American citizen has the right to protection of persons, house, papers, and effects from unreasonable search and seizures. In many criminal investigations, the process of a search and seizure is necessary to find evidence and prosecute a suspected criminal. If this evidence is found outside of the constitutional guidelines, the evidence becomes unadmissible in court, thus making prosecution of a criminal unlikely, if not impossible. Without proper warrants and reasonable justification or probable cause, it is unconstitutional to perform any search or seizures. This same idea also applies to improperly obtained confessions as included in our Fifth Amendment rights. Exclusionary rule itself ensures that evidence secured by illegal means and in bad faith cannot be introduced into a criminal trial. The technical term is that it is excluded upon a motion to suppress made by a lawyer or a defendant. It is based on the constitutional requirement that no person can be deprived of life, liberty, or property without due process of law. A technical error in a search warrant made in good faith and signed by a judge or magistrate will not cause exclusion of evidence obtained under the warrant, provided the error was reasonable and understood. When obtaining a search warrant, an investigator is specific in what evidence they are looking to obtain, and the warrant specifically lists the evidence and legal means of obtaining it. It must also include exact locations being searched. However, evidence which was uncovered as a result of obtaining other evidence illegally will be excluded from a criminal trial, under the fruit of the poisonous tree doctrine. Thus, if an illegal surveillance reveals the location of other evidence, both the transcript and the surveillance and the evidence to which the listener was directed to find will be excluded from a criminal trial. The exclusionary rule has been in existence since the early 1900s. Before the rule existed, any evidence was admissible in a criminal trial if the judge found the evidence to be relevant. The way in which the evidence had been seized was not an issue. This began to change in 1914 when the United States Supreme Court devised a way to enforce the Fourth Amendment. In Weeks versus the United States, a federal agent illegally conducted a warrantless search for evidence of gambling at a home of Fremont Weeks. The evidence obtained and seized in the seizure was used at trial, and Weeks was convicted for transporting lottery tickets through the mail. On appeal, the court held that the Fourth Amendment barred the use of evidence secured through a warrantless search. Weeks' conviction was reversed, and the exclusionary rule changed the way evidence would be obtained forever. Until 1960, the early exclusionary rule dealt only with federal cases. The silver platter doctrine was used to permit the use of evidence in a federal court that had been illegally obtained by state officials that did not involve any federal participation or federal direction. The problem with this existed with state and local officials performing illegal search and seizures, violating citizens' Fourth Amendment rights. In Elkins versus the United States, 1960, the Supreme Court finally abandoned it. The doctrine undermined federalism, the justices concluded. Almost half of the states had by then adopted the exclusionary rule, so admitting illegally searched evidence in federal court defeated the state court's effort to uphold the Fourth Amendment standards. The next year, in Mapp versus Ohio, 1961, the Supreme Court made the exclusionary rule binding on all state courts, thus ending completely the tactics prompted by the silver platter doctrine. My personal opinion of exclusionary rule is that it is absolutely essential in due process of law, and the idea of innocent until proven guilty. I can see the counterpoint of the issue as well. Some would argue that it takes up too much time. Anything that's found should be used in a criminal trial. However, that is not what the law says. As law-abiding citizens, judges, magistrates, defense attorneys, and defendants themselves must follow the law. It does require excellence from our uniformed investigators and sometimes does impose unnecessary costs on society. In certain issues, it can cause the subject to go free. I feel the responsibility to uphold exclusionary rule lies upon the prosecution to obtain evidence legally so there are no loopholes for the suspects to jump through. The rule may not be perfect in a society that suffers from violent crimes frequently, but each of us is entitled to certain protections. The exclusionary rule's best accreditation is the fact that it deters police misconduct and holds accountable each and every officer to protect our Fourth Amendment constitutional rights.